Let me welcome again everyone to this webinar on market exclusivity for pharmaceutical products in Europe. I am David Olson. I am a professor at Boston College Law School, and I'm the faculty director of the BC Law Program on Innovation and Entrepreneurship, which we call PI for short. It is our great pleasure to co-host this program with the EU and UK law firm of Kilburn and Strode. Part of our program's goal here at BC is to bring together people to talk about important legal issues affecting innovation. A key tool for encouraging innovation in the pharmaceutical space is market exclusivity for drugs in the form of patent extensions and data exclusivity. These tools are sometimes derided as methods of unfairly profiting from patients, but they exist for a reason: to encourage innovation, which innovation lawmakers think would not happen but for the exclusivities. The issue, of course, is one of balance, and it's an important issue to policymakers and academics. But to understand that balance, we in policy and academia need to really understand how these exclusivities work and are used. Correspondingly, for those actually participating in the market, these exclusivities are of critical importance to their approach, to their planning of innovation, to their profitability, and to their participation in the market. By co-sponsoring events like these, where we bring together people who are doing the work, seeing the things on the ground in an academic setting, where academics can also take advantage of this detailed knowledge, we further the goals of the program on innovation and entrepreneurship, hopefully to the benefit of all. So it's a great pleasure to be co-hosting this. I'm just going to go over now a few ground rules before we get started. And then I'm going to turn the meeting over to our chair for the webinar, Jennifer Harris. So just a quick reminder that this is in webinar format. So while you can see and hear the panelists, or at least the panelists who are speaking, they cannot see or hear you. If you'd like to communicate and ask a question, you can use the chat function to interact with the panel and each other. And there's also the Q&A function where you can ask questions for the panel. You can find both of these tools at the bottom of your screen. The panelists will be using the Q&A function to select and answer questions from the audience. Also, we're recording this, and it will be available later, so there's not a need to worry about taking notes or screenshots as we speak. That's it for the housekeeping. By this point of the world, I think we all know how to use Zoom fairly well. So without further ado, let me turn it over to our chair, Jennifer Harris. Jennifer Harris is a European patent attorney and a partner with Kilburn and Strode. She has extensive experience representing clients in relation to their patent portfolios for drug products and candidates in clinical trials. She's recognized by IAM Strategy 300 as one of the world's leading IP strategists, and I'm very thrilled to have her and her colleagues here and our panelists here to discuss this important issue. So without further ado, I will turn it over to you, Jenny.
Thanks so much, David. We're really pleased to be here. Now, let me welcome our fantastic panelists, Nick Bassil, Nicole Jadeja, and James Horgan. We're really pleased to have you all here. Just quickly, Nick is a partner here at Kilburn and Strode and a true expert on patent term extensions in Europe. Nicole is a solicitor at law firm Pinsent, and Nicole has extensive experience working at the interface between IP, commercial, and regulatory law. And James heads the European Patent Department for pharma giant MSD. So let's get started with what we're going to cover. First up, Nick is going to give us an overview of patent term extensions for pharmaceutical products in Europe. Following that, Nicole will talk to us about regulatory exclusivities that exist in Europe and consider how they, along with patent term, influence pharmaceutical product life cycles. James is then going to share some of his experiences from the sharp end. After Nick, Nicole, and James have all spoken, we'll have some time for the panelists to answer some questions. So please do submit your questions as we go along using the Q&A function that David mentioned. We'll get through as many of these as we can. And with that, I'll hand over to Nick to get us started. Thanks, Nick.
Jenny, many thanks. So as Jenny said, I will be talking through the highlights and main points of the Supplementary Protection Certificate system in Europe. And next slide, please. Next slide, please. So I'll briefly touch on the main elements of the legislative framework, touch on the substantive legal provisions, and then move on to SPC filing strategies and factors that applicants may need to consider, and hopefully setting the scene for Nicole and James to talk in more detail on some of the more interesting implications and ramifications of these areas. So next slide, please. So the SPC system in Europe. The governing law in Europe, in the European Union, comes from Regulation 469 of 2009. And this has direct effect in the member states of the European Union. It's also been adopted in some of the states of the European Economic Area. In this area, we see a lot of case law from the Court of Justice of the European Union, the CJEU. This is the relevant court for deciding on questions of interpretation of EU law questions. So that's relating to SPC validity and also matters where SPC applications have been refused by the National Patent Office in the country concerned. In the UK, we have the same SPC law as in the European Union. We copied over the European Union law into our domestic law. There are transitional provisions from the withdrawal agreement, and it's important to note that existing case law from the CJEU has been retained, and the UK has the opportunity to diverge in the future, and we'll have to see how that plays out. The situation of Northern Ireland is interesting in this case. The European Union marketing authorisations issued by the European Medicines Agency will still have impact and effect in Northern Ireland. In the case of Switzerland, there is also an SPC law in force. And as many of you may have heard, the unitary patent in Europe is coming, but there is no formal announcement yet on whether or how an SPC could be based on a unitary patent in Europe. Next slide, please. So the SPC system in Europe is actually a national system. So when applying for an SPC application, it's necessary to apply at the National Patent Office in the country where you wish to obtain protection. So even if the underlying patent has been granted by the European Patent Office, you'll need to be filing your SPC applications in the countries in which the European patent was validated. Or you can base an SPC application on a national patent granted by a national patent office. But it's also very important to note that not all states designated in a European patent application have an SPC law. So for example, Monaco or Turkey. But as countries try and join the European Union, their laws are updated, and it's then possible to file for SPCs in those states as their laws are updated and they join the European Union. So for every SPC filing program, it's necessary to check on the territorial scope of the basic patent on which you're hoping to rely for protection. Next slide, please. So the main features of the system, it's a product-specific system. So it's not patent term extension as you're familiar with in the USA. The SPC is a new IP right in its own right. It relates to the basic patent, but it has its own separate annuity fees. The protection is provided for the product covered by the marketing authorization to place the corresponding medicinal product on the market. There's no protection available for a product already protected by an SPC. So that's a particular issue if the product concerned is a reformulation of a known product. And no protection for products not authorized by the standard procedure for regulatory approval in the directives 2001 of 83 and 2001 of 82. The term of protection under an SPC may not exceed 5 years, and it's subject to a calculation, so it can be less than 5 years. There is, though, this possibility for a 6-month extension of term under the pediatric extension, which Nicole will touch on in her presentation. Next slide, please. So when to apply? The deadline to apply is 6 months from the date of grant of your marketing authorization, or 6 months of date of grant of the basic patent if later. Where the marketing authorization is granted by the European Medicines Agency, that date of grant then will be the same in all EU member states. And remember, as I said, an EMEA authorization is also relevant for Northern Ireland. Where to apply? At the National Patent Office of the state concerned. I'm not going to talk about plant protection products, but there is a system for legal protection for those products also. That's outside the scope of this presentation. Next slide, please. So I'll now move on to some of the questions arising from the main legal provisions for SPC applications. Next slide, please. So Article 3 in the regulation sets out the conditions which are necessary to be satisfied in order for an SPC application to be granted. And this slide is part of the pack you'll be able to have access to, so you can read it in more detail subsequently. Next slide, please. So Article 3A dictates that the product must be protected by a basic patent in force, and this has been the subject of much legal interpretation. It's not an infringement test. It's more akin to a disclosure test. And you can see from this slide that there have been many cases where we've had to consider what this phrase protected by the basic patent actually means. Next slide, please. Articles 3C and 3D also cause applicants problems because they exclude from protection products already the subject of an SPC, and also concern the question of when a product has been the subject of an earlier marketing authorization. So again, difficult questions for applicants to address and some elephant traps for the unwary. Next slide, please. Just to point out the effects of an SPC, it provides an applicant with the same rights that exist under a patent, but it's limited to the product that's the subject of the authorization to place the product on the market. Next slide, please. Lastly, to touch on the SPC manufacturing waiver, which some may have heard of. This is an exception to patent infringement. It's possible to manufacture a product covered by an SPC in the territory of a European Union member state or the UK, where the product is for export. Next slide, please. Next slide, please. So lastly, I just wanted to summarize, and although this presentation has been brief, to try and highlight some of the key facts for taking into consideration when deciding on where and how to file an SPC application. Where you have a choice of patent, maybe you have divisional filings, maybe you have multiple filings in a particular series of filings, look at where the patents have been validated, look at the expiry dates of the patents, look at the patent claims. Do they protect the patent according to the regulation? Look at the marketing authorization definitions. Is there a match up between the product definition and the marketing authorization? Look at the applicant identity. Look at the strength of the patent claims. Are you vulnerable to a post-grant challenge? And lastly, consider the opportunity for whether pediatric extension could be obtained either at the time of filing the SPC application or subsequently. And that concludes my presentation, and I will now hand over to Nicole. Thank you very much.
Thanks very much for that, Nick. And let's welcome Nicole to give us a run through of the situation in Europe relating to data and market exclusivity.
Excellent. Thank you, Jenny. Thank you, Nick. I'm absolutely delighted to join the session today to give an overview of the regulatory exclusivities in Europe and the value they can bring to the life sciences sector. So we've heard from Nick about the important role that SPCs can play, and what I'm going to do is start by looking at the interplay between the patents and SPCs and regulatory exclusivities. If I could have the next slide, please. And then what I'll do is go on and explain at a relatively high level the incentives that are available in Europe. But before I went into that detail, I'd like to just sort of set out the context as to where these fit in the overall system and the overall drug development pipeline. If we can go on to the next slide, please. So what this slide does is provide some context as to the role and importance of exclusivities. And I thought it'd be particularly helpful for those in the audience that are perhaps not from the life sciences sector, although I appreciate, given everything that's gone on in the last 2 years, and people will be a lot more familiar with the overall picture as to what happens in the sort of a drug development program. So what this does, what this slide illustrates quite neatly, I think, is the general concept that the investment that needs to be made in the product during the preclinical and clinical phase. You can see there where sort of the dip in the orange and the blue line representing the earnings. And then what happens is that window of opportunity for the rights holder to recoup investment during the product term before the market declines. So what you'll see is essentially the product value increases during the patent term once a product's been authorized, so that registration mark on the slide there, and then it reduces in value in advance of patent expiry in anticipation of competing product entry. So that period of exclusivity post receiving your registration or your market authorization is absolutely critical to companies developing products. If we can move on to the next slide, please. I think this is a really great image which has been put together by EFPIA, and that's the European Federation of Pharmaceutical Industries and Associations. And what this does is show that interplay again between patents and regulatory exclusivities and how that sits in this drug development pipeline. So you can see in orange, sort of the typical, sorry, just above the line in orange, you can see that that product development stage can take 12 years, perhaps longer, perhaps less, but just sort of as an overview, about 10 years, during which time the product will be going through development in clinical trials. Your patent protection would last for 20 years, with filings typically taking place at the inception of an invention and before product development. And then, as you can see, sort of the orange going into the blue, we've got the SPC and the pediatric extension, which Nick was speaking about. So running alongside that, underneath then in green, is the regulatory data protection, which is a system often referred to as the 8+2+1. You can see the 8+2+1 there on the slide, and I'll sort of elaborate on that in a moment. And you can also see beneath that there are sort of a host of additional incentives for medicines which qualify for orphan designation. And those are medicines which target rare disease. And those incentives have been put in place in Europe, recognizing the challenges of developing and investing in products intended for a very small patient population. If time allows, I'll come on and show how this might play out in practice, because it can differ to some extent, but that does give you the overall picture. So moving on then, please, I'm going to look at the 5 key exclusivities that often play a role in Europe: data exclusivity, market exclusivity, exclusivity when you've developed a new indication, orphan exclusivity, and pediatric exclusivity. So moving on then. As we've seen sort of from the earlier slides, in order to obtain a marketing authorization, pharmaceutical companies need to submit extensive data relating to the preclinical and the clinical trials to demonstrate quality, efficacy, and safety of the medicine to be approved. And now what the system sort of was mentioned in the introduction is that need for balance. So we need to produce that data and make it available to other people, compensate those that have generated that data and put the investments and time into generating that data, with the need to make sure that competitor products coming onto the market after exclusivity don't have to do an unnecessary repeat of tests. So data exclusivity then. Under the EU data exclusivity laws, the data used in marketing authorizations cannot be used by a generic company in an abridged application to obtain approval for their own products for a period of 8 years. So that gives the company that's sort of done the innovation at the outset the opportunity to have an 8-year period under which their data cannot be used. They've got exclusive rights in that data. After that period, anyone can rely on the innovator's data in the abbreviated application for their marketing authorization. I guess it's worth highlighting that this doesn't prevent a company submitting its own full standalone application, but obviously with the generic model, that's often not what companies are wanting to do. They're wanting to rely on that data under the abridged process. So the 2, and this is where the 8+2+1 comes in, the 2 relates to market exclusivity. And what that means is once the period of data exclusivity has expired, you can get an additional 2 years, so during which time that abridged product, that generic product, may not be placed on the market. So during that 2-year period, they can rely on the data body that's been created to prepare their own marketing authorization dossier, but they can't yet put their product on the market. And you'll see there's an additional 1-year market exclusivity available where a new therapeutic indication has been developed, which is considered to bring a significant clinical benefit. And as you can imagine, there are various guidelines as to what is meant by a significant clinical benefit. But ultimately, that's where your +1 year comes in. And there are lots of really interesting questions, which we don't have time to go into today, but as to when that period of regulatory data exclusivity starts and the extent to which you can have a new period of regulatory data exclusivity when certain developments have been made to a product. And like I say, that's raised some quite interesting legal questions in recent years. So moving on then, please, to orphan exclusivity. As I explained at the beginning, this is a specific incentive to develop products to treat rare diseases. And it's a recognition, I think, that without that incentive, the returns on the products are unlikely to justify the investment because they target such a small patient population. There are various criteria which have to be satisfied in order to qualify as an orphan product. So it has to be intended for the treatment, prevention, or diagnosis of a disease which is life-threatening or chronically debilitating. The prevalence of the condition in the EU must not be more than 5 in 10,000, or it must be unlikely that marketing of the medicine would generate sufficient returns to justify the investment needed for its development. And finally, there must be no satisfactory method of diagnosis, prevention, or treatment of the condition concerned, which hasn't existed already, and that must be of a significant benefit to patients. So how does this one work? Well, this provides market exclusivity for a period of 10 years against similar medicinal products. So that means that during that 10-year period, the regulatory authority cannot accept an application for nor grant a marketing authorization for a similar medicinal product. Again, as you can probably imagine, there's lots of guidelines as to what is a similar medicinal product, which I won't go into today, but suffice to say, it's a broader right than data exclusivity. Now, during this term, then, companies cannot get a marketing authorization for the similar product, but there are some exceptions to that. There are situations where the marketing authorization holder could give consent. Then there might be a situation where the original market authorization holder is unable to supply sufficient quantities of the product, and the applicant also has to provide evidence. There can be situations, where an applicant provides evidence that its new medicinal product is safer, more effective, or clinically superior. And again, lots of guidance around what clinically superior might mean. So this is it's quite an effective right for companies who have developed products within that orphan designation status. It is worth saying that 10-year period can be reduced to 6 if after 5 years the original medicinal product no longer meets the criteria for orphan designation. And as I might have mentioned, it can also be extended. It can be extended to 12 years if a paediatric investigation plan has been completed. And I'll come on and explain what that is in a little bit more detail now in the context of paediatric exclusivity. So the next slide, please. So this applies to all new products, or for older products where an application is made to vary the marketing authorization. And this has come into play because there's an obligation in Europe introduced on pharma companies to research and develop medicines in children as well as in adults. So when you're developing a new medicine, you need to submit a paediatric investigation plan, which sets out the studies that will be done to investigate the safe use of a medicine in children. And that has to be carried out in compliance with this paediatric investigation plan, or you'll hear people refer to that as a PIP. And where that work is being completed, there is a reward system to recognise the work that has been done, the sort of extra research that has been done. And there are two key incentives. As Nick explained, you can get up to a 6-month extension to your SPC if certain criteria are satisfied. And when the product, which is the subject of the completed PIP, is an orphan medicinal product, the 10 years of market exclusivity under the orphan regulation can be extended by a further 2 years. It's worth saying that both of these will apply when you've completed your PIP, even if those trials have not in themselves led to the authorization of a paediatric indication, because the aim here is very much to reward the research efforts and not the outcome. I'll just mention briefly that have these worked, I guess, have the paediatric exclusivity regime and the orphan exclusivity regime, have they worked in sort of incentivizing what they were intended to do? For those that are interested, there's a really interesting joint evaluation which was carried out by the Commission, and that's looked at whether or not these have worked, and overall they sort of indicate that they have helped to redirect funding. There's some interesting findings about whether they've adequately supported development in the key areas where the need for medicine is greatest. So yeah, it's an interesting report to have a look at for those that are interested to see how these incentives have actually, whether they've achieved the goals that they were introduced to, So finally, then on the last two slides, I just wanted to show how these have played out in detail. I don't know if you can, sorry, you might have to do quite a bit of clicking, Ella. But essentially what this slide shows, this is an effect, the same sort of slide that we saw at the outset. So that shows that you have the term of your patent for 20 years, there's the potential SPC term, and then there's a pediatric extension. And that shows that from the grant of date of the marketing authorization, various data exclusivity and market exclusivity protections came into effect. There's your 8+2+1, but it doesn't in effect extend that period of exclusivity beyond the term of exclusivity you would get through the IP system. But if we just go on to the next slide, please, you can see how that plays out slightly differently on another fact scenario, where perhaps the grant of your marketing authorization takes place at a later time during the term of the patent. For example, because the clinical trial process has taken slightly longer. And here you can see where the data exclusivities and regulatory exclusivities can really play quite a key role, because they then kick in at the grant of the marketing authorization. But you can see here then, provided they all qualify, your 8+2+1 will actually extend the exclusivity period beyond those which you could achieve through your IP portfolio. So I think what that illustrates is that, you know, companies looking at their product life cycles, or generics looking to come onto the market, must look at both the IP system and patents and SPCs in combination with the regulatory exclusivities, because the two do go hand in hand and they don't always tie up neatly. And strategically, you can think about how you might deploy one over the other, and generics will similarly be looking at that landscape and working out, you know, when they can take the decision to launch their product. So that gives you a very sort of whistle-stop overview of the regulatory landscape. But I think now we're going to, I'll go back to Jenny, and then I think we're going to go to James to look at some of the practical implications of this.
Thanks very much for that, Nicole. And just for the audience, can I remind you that we will have some Q&A time at the end of the three presentations, but please do go ahead and submit any questions as you think of them, and we'll make sure that we collate those. So now if I can pass over to James, who's going to tell us a bit, I think, about his real world experiences and learning from his time in practice. Thanks, James.
I'll mute myself. I didn't realize I was mute. Right, great. Hoping people can hear me. So just to bounce very quickly off something Nicole said in relation to the reduction that may occur with orphan protection. I'm not aware that's ever happened to a product. So although that's there in theory in the law, it's not happened. And from a pharmaceutical industry perspective, the orphan system has been quite successful. And because it's been quite successful, of course, the EU wants to take away some of the incentives, which is a bit of a pity, because it's been very useful in helping find treatments for rare diseases. Also, the extra year of regulatory data protection that you can obtain through a significant new indication has in practice proven harder to obtain than people might have thought initially in the way the original guidance was written. So although there have been instances of people getting it, it's not that common. So when you come to analysing what you think is the most likely thing to happen with protection, you can probably usually discount getting the extra year of data protection and usually not worry about a reduction in term for orphans. I'm not saying it'll never happen, but it's not common. I wanted to talk a bit through some of the practicalities of obtaining SPCs and how you might go about thinking about some of the issues strategically and practically that are involved in getting them. Now, I head a small in-house department for Merck Sharp and Dohme. It's known by another name in the States, as I'm sure many of you know. Between us, historically, we've filed about 4 to 5% of all SPCs throughout Europe ever. So we have quite a concentrated expertise, and that's led to various court actions in countries, We've had cases at the Court of Justice of the European Union and also the EFTA Court. So we have quite a lot of practical experience. And one of the things that's nice doing this work in-house is that we actually coordinate filing programs so that we see not only the practice in our own individual country, but we see what happens to an SPC application through all the territories in Europe with all of their quirks and oddities. And that gives us a big picture overview of how to go about the process. One of the things I think is a takeaway actually from looking at SPCs, you may be looking at this process thinking it's quite complex, is that in most cases, an SPC application is pretty straightforward, in most cases. But guess what? The most cases aren't the things that take up the time of all the legal analysts. But if you've got a regular small molecule, and you've got a patent covering your small molecule, and you get a marketing authorization, and the numbers all crunch up correctly, getting an SPC is pretty straightforward. And certainly it's far more straightforward than it was when I originally started in the profession, when you were relying upon national marketing authorizations and the mutual recognition process, and you needed copies of the paperwork from each country. There was no internet for doing this. You needed copies of publications and official gazettes, and who knows where the Italian official gazette is published. So it's now, everything is pretty much online. So when we send off instructions to our corresponding agents in other countries, it's a single email with various links in or various documents embedded in it, and all this material is online. So this is quite a straightforward process. The things we would normally need to include are the marketing authorization, which in almost all cases these days is a centralized EU marketing authorization. So that's on the web, that's very easy. A copy of the patent and indication of which claims cover the actual product. Evidence of the structure of the active ingredient and its INN and its sort of the name that's used for it, because of course you have to tie together the chemical nomenclature of the patent and the INN that will be used in the marketing authorization. You also need to decide on a product definition. Again, in many cases, that will be straightforward. The active ingredient in any of the forms protected by the patent. Sometimes you just say the actual name of the active ingredient. You don't seek protection usually for the salt or an ester or some sort of form of the active ingredient, but the active principle itself, assuming that that's protected by your patent. This is a very, very straightforward process in most cases. More complexity, though, arises when you have a number of patents on which an SPC can be based. And that's because of a number of interlocking rules that have been established through jurisprudence from the CJU. There is, in general, a prohibition on a party obtaining more than one SPC. But that's not applicable if the patents are held in different party names. So that can sometimes be got round, or it may not be an issue, or depending on where you're at, you may only have the one patent, so the issue never arises. But what the CJEU has done in recent years, as it has tightened the rules on which patents qualify to obtain an SPC. Now, Nick did touch on this before, some of the jurisprudence on Article 3A, which talks about the requirement that the product is protected by a basic patent in force. And the rule on what's protected is a sort of identification test. Can you identify within the claims or within the description of the patent, the actual molecule, potentially also within the prior art if you have some kind of functional definition. And so some of the types of patents that people might have used in the past, particularly for hostile SPCs, are unlikely to receive SPCs going forward. And I think of the types of cases that have given rise to the case law, such as class-based second medical use, or what you would consider to be method of treatment claims. The classic example being that in the Royalty Pharma case, where there was a case essentially for a method of treatment of diabetes with a DPP-4 antagonist. So that covers all the gliptins. The only downside as far as Royalty Pharma were concerned, and the reason they didn't get any SPCs, is that none of the actual molecules in the gliptin class had actually been invented at the time they filed their application. And under those circumstances, it was impossible for the skilled person to identify any gliptin in the scope of the claim. So you'll find that the number of SPCs available is rather diminished compared to the situations in the past, and that makes business predictability easier if some of the fun of getting SPCs that are hostile and causing trouble for people are a little less exciting. Now, one of the complexities, though, that does arise from this, assuming you have patents held in the name of one party, is deciding which patent to use to get your SPC. Now, again, you may have the simple case, you may have a choice of one, in which case it's simple. But I think in the small molecule field, you may come across circumstances where you have a generic Marcouche claim and a specific selection patent on an individual molecule. Now, assuming that the numbers stack up such that you can choose either of them to base an SPC on, and often when you can do that, the term of the SPC, because of the calculation on the cap, means whichever you choose, they will be expired at the same point. You then have to make a slightly difficult choice between two patents, one of which clearly is going to be much easier to satisfy the SPC regulation on because you can very clearly identify the molecule, versus the fact that that will be a later patent and potentially more vulnerable in terms of patentability attacks. And you're going to have to decide under those circumstances which of those two patents to go for, which may take some rather complex analysis and a bit of humming and hawing and hoping you get it around the right way, because of course it's going to look pretty difficult in due course if you've put your eggs into the basket of one of the cases that then, or particularly if it's the specific case, I suppose, that gets knocked out for some lack of patentability inventive step reason later on. But that bullet, I'm afraid, will have to be bitten and a decision will have to be made. You can't hedge your bets and get two SPCs, which would have been the easiest solution under those circumstances. Now, I think you can base patents on different types of cases. You can base them on second medical use cases, compound cases, formulation cases within limits, although not where you're trying to claim the formulation as part of the product. And you might think from reading the regulation you can't use those, but in practical terms, you often can. Process cases if you have them, but clearly the scope of any SPC that you get will be limited by the scope of the patent. So if you based your SPC on a method of treatment case, a second medical use case, then the protection you've got from that SPC will only extend to uses that are within the scope of the patent, won't cover the compound as such. Now, this analysis becomes more complex still, and I think this is probably where things are likely to be see some action at the moment, in the sense of in terms of biologics. Now, the challenge with biologics, as I'm sure many of you will appreciate, is unlike small molecules, it is not easy to exhaustively define them. And as a result, when you're choosing a patent on, and you also tend to have rather more patents on a biologic than you do on a small molecule, because there are incremental inventions made in defining things more precisely, or formulating, or coming up with greater characterization of these molecules. You've then got to decide which of those patents to use and be prepared potentially to argue that if you don't, for instance, have a full amino acid sequence, but maybe just some CDRs in there, or some other way of defining, but with functional terms, that does satisfy the requirements for the skilled person in defining the invention with the requisite degree of specificity. Now, one cautionary tale I can tell you is result is out of the Irish Patent Office, and it's to do with a vaccine to herpes simplex virus 1, that's cold sores, and the vaccine was the HSV1 virus, but with 2 gene deletions. Now, there were 2 parties which had 2 patents. One of the patents specified both gene deletions, and an SPC was duly obtained upon it. The other party had a patent that just mentioned one of the gene deletions. And under those circumstances, the Patent Office held that didn't sufficiently specify for the skilled person the actual nature of the active ingredient, and an SPC was denied. So one does have to be quite careful in this area, and I think we're going to find some more disputes going on with that. Now, managing prosecution of a family of SPCs. It's quite common to get minor office actions when you filed SPCs. I mean, the UK is just a desperate fan of writing an office action that says, please, please, please confirm you didn't get a Swiss marketing authorization before your first EU marketing authorization, because there are rules under which that changes the term calculation, even if you've told them at the very beginning you didn't have one. So I think they have a box to tick that they've issued an OA. Some countries don't give office actions, they grant within a few weeks. Some countries want to make trivial changes to some part of the application, maybe the way that you've expressed the marketing authorizations, maybe the precise way you define that you have a product definition. Now, a product definition is not the same as a claim. You haven't got to be quite so nervous about the way it's worded. I've yet to come across, I think, any form of litigation or any situation where the very precise wording of the product definition actually had an impact. So don't get too worried about that. I mean, go with the local advice you get. Usually, I would say it's usually simplest to aim for something along the lines of the name of the active ingredient by INN in any of the forms protected by the basic patent or something like that. And some countries won't give you that language, but they'll have a little asterisk and at the bottom of the form it says, in the bottom of the certificate, it will say, in any of the forms protected by the basic patent. So these things tend to come out in the wash. The other thing I think to bear in mind with the use of an SPC is it's used to keep generics off the market. Generics, of course, will inevitably sell a product that may be a different salt form but will contain the same active principle. And when it comes to biologics, I think the trend with biosimilars will be ever closer convergence to the reference product and expectations from the EMA for that. So I think you'll find you haven't got to worry too much about thinking you need some sort of broad scope in a product definition, because biosimilars will be squeezed down to looking as much like your product as possible. And so you will clearly be infringed, your right will clearly be infringed by a biosimilar with an SPC term. Now, you may get oddball objections in some countries, and certain countries are famous for that. And my general encouragement to applicants is to deal with oddball objections robustly and consistently. The reason being is pour encourager les autres, as the French would say, which is to encourage the others, and the examiners there as well. You don't want the examiners succeeding with an oddball objection, because you will then find it on every other application ever afterwards. And if you don't deal with it today, you'll have to deal with it tomorrow, or some other poor chap will have to deal with it if you don't. So it's never good to let patent offices get away with stuff on SPCs. They are highly valuable and important rights. Some countries have odd practices. Bulgaria, for instance, I think this is ultra-virus, but nobody's bothered pushing it because it's more trouble than it's worth, requires a document confirming a link between the marketing authorization holder and the patentee, often asking for evidence of a license. Now, that often doesn't exist as such, because the entity you've got holding your MA may not be the party on any licensing deal you've got. So you may need to run around and sort something out to satisfy that, though they do give you a very long term, usually several years, to comply with that. Or sometimes, I think as often we find, the company is part of the same group, so you can generate some sort of letter confirming that the companies are part of the same group, even though the marketing authorization holder and the patentee both contain the names Merck, Sharp and Dome, and you would have thought that was obvious, wouldn't you? Now, don't forget that certain jurisdictions like Switzerland, Norway, Iceland, the UK need their own separate applications as a result of other actions that take place at marketing authorizations. The Norwegians and Icelandics, of course, rubber stamp essentially the EUMA a little after it's been granted, but you have a separate term for them. And I think Nick has already mentioned about the need for 2 SPC applications in the UK, one for the covering Northern Ireland essentially, after the EU one, and then one after the GB covering the rest of the United Kingdom. You've got a 6-month term to do both. You get 1 SPC, but the enforceability is limited to the territory for which you supplied the marketing authorization. So do not forget. That's important. Moving on to, and I would just tell you what one amusing, I don't know, I put this in my notes somewhere, it's around, one amusing horror story. I'll come to that actually further on. So just quickly on RDP. RDP is an automatic right. It's rare for it to be challenged. There are 1 or 2 very obscure instances around. You're highly unlikely to be in the situations where that occurs. And it's an automatic right by which the regulatory authorities will not award generic marketing authorizations. So litigations on RDP are rare. It's a very powerful right. And if that is your last to expire right, determining your loss of exclusivity, you can pretty much be sure that that is going to be a very hard date and won't be challenged. Usually, though, it's not. I'd say it's about 10% of cases where that occurs. Litigating SPCs. Now, that usually only happens when there are questions about the validity of the SPCs, because a generic, just as with a very strong patent, isn't even going to try their chances against it, usually. So you may find you have to litigate SPCs where there is a challenge to the underlying patent, or where there are questions about whether an SPC is infringed. So there used to be historic questions about whether a mono SPC would protect a combination product. And the answer is yes, it does. Or whether the sale of a different ester or salt would infringe an SPC where the product didn't necessarily specify that particular salt. And the answer is yes, it does. So those situations you won't come across again. When you get into litigation, it's a little bit like a mini patent trial, but not quite so technically complex. And that's the full range, and a different talk, obviously, on national litigation procedures, where you may need experts. You have different types of procedures in different countries, and also you get a great experience in how to do litigation around Europe. Litigation, of course, has to be done on a national basis, because these are awarded as national rights. Moving on just quickly to pediatric SPC applications, which Nick mentioned again. The deadline for those is 2 years before SPC expiry. That might sound like a long time, but often your PIP completion and the statement that you need to obtain from the relevant committee that says you are entitled to your reward comes awfully close to the wire. It is possible to file your application without all the documentation you need, as long as you get it a bit not too long afterwards. But you can only push that so far. but that can be quite a challenge. Now, one of the problems, I think, from a business perspective is patent offices can be slow. Because the deadline for filing extensions is quite close to SPC expiry and patent offices are slow, you often have your business champing at the bit, wanting to know if this SPC extension has been granted, and some patent offices just don't pick the file up. There are informal ways of trying to speed them up, but they can also be slow examining regular SPC applications. There are one or two offices which are infamous for picking up cases filed with them in expiry date order, not on the date you filed them. So one patent office, which I shall, for the purposes of this, will remain leave nameless, has an application that I filed with them, I forget when, something like 2003. The patent expired in 2008, and the SPC should have expired in 2013. I got an office action earlier this year. Yes, that is true, raising loads of objections that no other countries did based on case law that's come out between 2013 and now, so that's a real pain. So I'm encouraging the others on that one, I can assure you. So I would encourage you, because of the slowness of patent offices, to try and turn office actions around very quickly. They're often pretty simple. There's no reason to delay them. You want these things to issue soon, so everyone's aware of what's happening. Now, before we run out of time, I'm just going to touch on two very quick topics. One is the Unified Patent Court and unitary SPCs. So I'm quite involved in debates going on with this with the European Union. The European Union is currently toying with plans to introduce some sort of legislation on a unitary SPC. They've not got as far as generating legislation yet, but hopefully it will come. In the interim, if the court comes into operation without this legislation in place and you get a unitary patent, there will be some sort of comfort notice that comes around saying you can apply for SPCs through the national routes, just as you do at present from a European patent. The caveat there, of course, you need to bear in mind is because they're based on a unitary patent, they will inherently fall unavoidably within the jurisdiction of the unitary patent court, of the Unified Patent Court. Last, and I think actually that was it. So that's all my stuff, and I think I'm perfectly on time. So I'm happy to take questions.
Thanks very much, James. Always interesting to hear you speak. So I have a couple of questions to get us started, and then if the audience want to submit any more questions, please do just fire them into the Q&A. So first off, I think this is a question that I'm going to ask both to James and to Nick, and I'd like both of their answers actually. So could each of you, so James, you mentioned that over the years, the requirements for obtaining SPCs have become stricter. Could each of you give me what you would say is your one top tip or your one top way in which you've changed how you approach patent prosecution in Europe, bearing in mind how the requirements for getting SPCs have become stricter? Or your one top tip for patent prosecution with SPCs in mind. Who shall I throw that one to first? James is smiling, so I'll ask James to answer that one first.
Yes, I have a good answer to that one. The top tip is actually to do with challenges in getting SPCs where you have a patent that covers a monotherapy and a combination therapy, because there is some case law that makes that quite difficult. So the top tip is that if you've got that type of situation, file a divisional to the combination therapy to try and avoid the problem. But watch this space, because I've just got a CJEU reference on that very topic. So that may change in a year or two's time, but that certainly has impacted my practice very considerably, and definitely in the last 8 or 9 years.
Thanks, James. And Nick, throwing that question to you.
I guess a similar sort of thing to consider, relating also to the grant stage of your European patent application or your national patent application, to look very closely at the claims before allowance. So the European Patent Office will issue the notice of allowance, and it's very easy at that stage just to pay the grant fees and let the thing go to grant. But don't neglect the opportunity to check in with your client and make sure that there is no product specific claim that you could perhaps, or you may want to include in the application that's going forward to grant. That's something that I do now much more often.
I think that's a very good comment, Nick, because I think there is sometimes within the sort of research or business side a desire to somehow submerge the identity of a product that may be being developed if it's not yet reached the market by the time the patent grants. That I can only say is not a virtue when it comes to getting an SPC. And getting a strong right that lasts a long time is probably more important than keeping your competitors guessing for a little bit longer.
Thanks very much for that, James. Now one to throw to Nicole. So James mentioned that regulatory data protection is a very strong form of protection. But do you ever see generics trying to challenge regulatory exclusivities? And if they were to challenge that, is there a particular mechanism for them to do that?
Yeah, I mean, as James says, it happens rarely, but it can happen. There have been a few cases, and the rules governing it are quite complex. It can depend to a large extent on the nature of the marketing authorization, which forms the basis of any decision. So you can challenge it, for example, where there's been an EC decision, you can sort of challenge it through the EU courts. There's also circumstances when you've got the right to challenge through the national courts. So it is quite complex, and as James says, it happens rarely, but there are mechanisms to do so where where you think someone has essentially got a marketing authorization in breach of your data or market exclusivity protection.
Thanks, Nicole. Another thing that was mentioned is that I think both Nick and James mentioned the unitary patent system, which looks like it's finally coming into play next year, probably. And it sounds like the how SPCs will be tackled under the unitary patent system is still somewhat open. Is there any indication of if there will be SPCs based on unitary patents, which patent office will be responsible for examining those applications? I can throw that out to either Nick or James.
I can deal with that one. So assuming there's no change to the legislation, you would, if you get a unitary patent which covers countries A, B and C, as you do now, you file your applications at each of countries A, B and C, and you will get national SPCs sitting under a unitary patent. If the proposal for a unitary unified patent, a unitary SPC goes forward, there isn't yet a consensus on what office will grant that. I think the leading proposal, which I came up with as an idea, is for a virtual office, and that may well be attached to something like the EPO for convenience. The challenge with that, or whether it's something, and the reason for a virtual office is because you won't get that many applications a year. Even if all SPC applications were funneled through it, they'd only get something like 100 applications a year. So you can't really afford a bricks and mortar office on that basis. The challenge with wherever you attach it to is you need to have an appeal route that runs up to the CJEU. So you will. There are ways of dealing with that. But yeah, so I think the EPO is probably a likely location for it, but potentially staffed virtually with national examiners who've got experience in this field of law.
Great, thanks very much for that. One more for Nicole. You mentioned in relation to the orphan protection that it also gave protection for similar products for the indication, and that obviously there's quite a lot of jurisprudence about what similar means. Are there any particular cases you're able to give us that give an example of what might be considered similar and what might not be considered similar?
Yeah, and perhaps just to clarify, I guess it hasn't necessarily come from the case law. There's something in the statute and also some guidance, but broadly, it's a similar active is something where the principal molecular structure is similar, but perhaps not necessarily all the molecular features, just sort of the structural features, for example, or acting via the same mechanism. So there's some examples given in the legislative framework, as opposed to sort of too much coming out of the case law.
Okay, thanks very much. I think that's all the questions we have right now. I'll just give 10 seconds in case anyone wants to throw any final questions in. But if not, I think I will pass back over to David, who is going to wrap up for us this lunchtime or evening for those of us here in Europe.
I'll give you a moment to see if any further questions come in? Seeing none, I just want to thank everyone, our panelists. I learned a lot from this discussion, and I think it's very valuable. It's been a pleasure to partner on this. And so I just want to thank Jenny for chairing it so ably. Thank you, Nick. Thank you, Nicole. Thank you, James. Those were really wonderful presentations. And thanks to Ella and Nate on our end for making all of this happen. So I hope everyone enjoyed it, and I wish you a good afternoon if you're in the US, or morning, possibly, and a good evening in the UK and Europe.